Hello everyone, today we are diving into an important and intriguing aspect of the US immigration permanent residency route using the EB2 NIW or the National Interest Waiver within the second preference employment visa category. This is especially relevant for any professional out there who believe that his or her work has substantial merit and national importance. The focus for today would be geared more towards explaining the misconception about the EB2 NIW or National Interest Waiver, specifically regarding the I-140 petition. Just a disclaimer, while I appreciate the kind comments and feedback around my knowledge in this space, I am nowhere an attorney or immigration lawyer. The content I create is based on 1. My knowledge in this process in seeking self-petitioning route for my own permanent residency, and 2. My experience going through this process myself, and lastly, the experiences of others. With that said, let's dive in, and for the first time viewers or those who are hearing about EB2 NIW for the first time, let's talk about this visa category briefly. Don't go anywhere, stay tuned. The EB2 visa is a second preference employment-based green card category available to individuals with advanced degree or individuals with exceptional ability in the sciences, the art, or business. The National Interest Waiver is a petition that allows you to bypass the labor certification process, which is typically required for EB2 visa. Now, putting it all together, the EB2 NIW or the EB2 National Interest Waiver visa category allows individuals with advanced degree or exceptional ability in the sciences, the art or business to gain permanent residency by bypassing the labor certification, as long as these individuals can demonstrate that their work or proposed endeavor is of substantial merit and of national importance. In your petition, you must be able to demonstrate that your petition meets all the 3 prongs USCIS look for to granting you approval for your I-140 petition. To qualify for the EB2 NIW, according to USCIS, you must meet at least 3 of the criteria on their website, and I have put the URL in this to this criteria in my video description. There are only 6 of these criteria USCIS are looking for. The first one is official academic record, showing that you have a degree or a diploma or certificate. The second is you have to have letters documenting, 10 years of, at least 10 years of full-time experience in your profession. The third one is license to practice your profession or certification. The fourth is you need to show evidence that you command a salary that demonstrates your exceptional ability. The fifth, you have to demonstrate membership in professional associations, and the sixth one is recognition for your achievements and significant contributions to your industry or field by your peers, government entities, professionals, or even your business organizations. Now, the question is, do you feel confident you meet at least 3 of these criteria? Chances are that you do. You are just underestimating yourself. Now, let's connect to see how I can help you see that you actually meet all of these criteria. You can reach me on LinkedIn or you can send me an email, and I'll be happy to connect with you to learn more about you and to also showing you that you actually meet at least 3 of these criteria. So again, thank you, and stay tuned. Don't go away as we dig into the misconceptions about this EB2 process, specifically with the I-140 petition. The EB2 National Interest Waiver process to securing your permanent residency or green card involves 2-step procedures. Now let's talk about this 2-step procedure, and I hope after this you would have a better understanding about this whole process. I believe having the right information better prepares you mentally and psychologically as you pursue this route. I have seen a lot of people, I've seen a lot of disappointment after explaining this process to people. The reason for the disappointment is because people expect the process to be way shorter than they had imagined. Yes, that used to be the case where there were no backlogs, and filing concurrently was, the order of the day. Now one can get his permanent residency in a year or less. Times have changed, and it's important to understand these dynamics and plan accordingly. Let's talk about the first step in this process. The NIW application involves filing the Form I-140 petition for alien worker along with the substantial supporting documentations to demonstrate eligibility under the NIW criteria. And this includes, but not limited to, evidence of the applicant's achievements, letters of recommendation from peers or recognized experts in the field, and documentation of work that has had a significant impact in the US economy. It is very, very crucial to understand that approval of the I-140 petition under the national interest waiver is not equivalent to obtaining green card. Now, the I-140 is a pivotal step in the green card process, wherein the U.S. Citizenship and Immigration Services, popularly known as the USCIS, acknowledges your contributions as significantly beneficial in a national level, thereby waiving the need for a job offer and labor certification. This petition primarily serves to classify an applicant under certain immigration categories that are eligible for the U.S. green card. Approval of this petition only means USCIS agrees that your skills and proposed endeavors have substantial merit and of national importance to the U.S. economy. However, right, the approval of the I-140 is only an acknowledgement of your qualifications and the waiver of the labor requirement, and it is not a grant of resident status. What that means is, if you should have your I-140 approved, it is not a change in your resident status. There is a second process, and we will talk about that soon. Let's talk about the second step or final step. So upon approval of the I-140 petition, the next steps definitely depends on whether the applicant is already in the US or abroad. Now, if the person already resides in the United States, you have to file Form I-485 to adjust your status to that of a lawful permanent resident. These steps involves a very comprehensive check, which includes your medical examinations, biometrics, and possibly an interview. However, if you reside outside of the US, then you have to go through consular processing at a US embassy or a consulate in your home country. This involves also submitting, your visa application and attending an interview with a consular officer. And what a consular officer primarily does is he or she will determine your eligibility to enter the US as a permanent residency. We will talk separately about the waiting periods and the visa bulletins in future content, but for now, it is very vital and important to maintain your non-immigrant status whilst your green card is pending or while waiting for your priority date to be current following your I-140 approval. And this is just for applicants who are already in the US, right? You have to make sure you maintain your legal status. The importance of this is you have to ensure you remain legally in the US during this process and avoid issues that could arise from overstaying or violating the terms of your visa. To recap, there are two steps in the EB2 NIW process. The first is getting your I-140 petition approved, and this is the difficult part, the hard part in this process. And then you have to adjust your status by filing Form I-485. I hope this explanation clarifies that filing Form I-140 and having it approved by USCIS is not the same as obtaining green card. Let me add that having a Form I-140 approved does not give you any working right or permit, meaning USCIS will not issue any working EAD for an approved Form I-140. Hope that sinks in. If you have any questions, please reach me on LinkedIn. My name is Richmond Adodankwa, or you can send me an email through my email is just adodankwar@gmail.com. In conclusion, while the approval of an I-140 petition is a significant milestone towards the journey of gaining your U.S. permanent residency, it is crucial to understand that it is not the same as green card. The I-140 petition approval simply establishes your eligibility under specific visa categories and is primarily concerned with classifying your qualifications and proposed employment as being in the national interest. The approval does not grant you the right to live or work in the US. It only allows you to take the next steps towards applying for permanent residency through the adjustment of status by filing the Form I-485 if you're already in the US or consular processing if you live outside the US. It's important for applicants to maintain valid immigration status throughout the whole process and to remain informed about the different stages and requirements. Understanding these distinctions helps set realistic expectations and prepare you for the journey ahead, ensuring you are well informed and ready to proceed with the necessary steps to achieving your permanent residency here in the US. Now, thank you for watching, and I don't take your comments and support for granted. Please keep sharing, keep subscribing, keep liking, and also let me know what you think about this content. If you find it very insightful, please let me know. And good luck in this process if you're already going through this process. If you have not begun this process and you want more information or clarification, as I already mentioned, please feel free to reach me on LinkedIn. My name again is Richmond Ado Dankwa. It's a pleasure here. Thank you.